It's 16 after the hour. Here's Katie.
Matt, thank you. Now for the latest on the fight over the body of Hall of Famer Ted Williams. On Tuesday, the former Red Sox slugger's will was made public for the first time, and it clearly states that Williams wanted to be cremated. But the executor of the will, a longtime friend of Williams, petitioned a Florida court saying that Williams had changed his mind and his body should be left in a cryonics facility in Arizona, where his son John Henry had sent it shortly after his death. Williams' oldest daughter, Bobby Jo Williams Farrell, disagrees. Robert Goldman is the attorney for Ted Williams' youngest children, John Henry and Claudia Williams. Mr. Goldman, good morning.
Good morning, Katie, and I appreciate you having me on the show. I wanted to, on behalf of Claudia and John Henry, tell you and the public how appreciative they are of the outpouring of sympathy for their father and what the family is going through. Thank you very much.
Mr. Goldman, let me just ask you about the will that became public yesterday. As I mentioned, it was written back in 1996, and it seems to make Mr. Williams' wishes pretty clear. In it, he wrote, "I direct my remains be cremated and my ashes sprinkled at sea off the coast of Florida where the water is very deep." Isn't that a binding legal document, and why do you believe it really doesn't represent Ted Williams' wishes?
Well, Katie, it is, first of all, not a binding legal document with respect to Mr. Williams' body and the disposition of his body. It is as to the disposition of his property. His body is not part of the estate. Now, to your other question, why we don't think it is, as Mr. Cassidy has indicated in his petition, Ted Williams changed his mind. He's allowed to do that. And under the law, he can do that in many different ways, and it doesn't require, by law, a change in his will or a codicil or any traditional method of doing that. As for the particulars in this case, I really would like to talk to you about it, and I apologize for not being able to, but I've been in this business of just doing trust and estate litigation for 20 years, and I know that when we get deeply into the litigation process, that one side's going to win and the family's going to lose, and they'll be apart forever. And so what we're trying to do is keep this matter as private as possible and see if we can't reach a private resolution, which is where this kind of matter really should be, and certainly where Claudia and John Henry want to resolve it.
But Mr. Goldman, from a legal standpoint, I'm just curious, if he changed his mind and decided he wanted to be frozen instead of cremated, that doesn't require his will to be amended? In other words, someone could just say...
It does not, Katie.
If somebody dies, someone could say, oh, you know what, she told me on her deathbed that she really wanted to be frozen. I mean, doesn't there have to be concrete evidence that there really was a change of heart? And what evidence do you have, if any?
Well, there does not have to be a change in the will. Let me be clear on that. And in your example of somebody changing their mind and orally changing their mind, might that be binding? Yes, if they can prove it. You say concrete, I would say preponderance of the evidence, and that's for a judge if you have to get there. Most of these matters are resolved in the living rooms around America, privately among family members, and that's where this one ought to be resolved, and we're going to give that one more try.
Did John Henry, his son, have power of attorney in the days prior to his father's death?
He did, but beyond that, I don't want to comment on the nature of those powers. Again, I think it's useful that the discussions about what the evidence might be had in the context of a confidential mediation umbrella where we can, in effect, be in the living room with Bobby Jo and talk about a common understanding of what Mr. Williams' wishes actually were.
Meanwhile, Bobby Jo Farrell was deliberately eliminated. Those were the words in the will. From the will, apparently, Ted Williams said that he had, because I have provided for her during my life. Was she surprised that she was not in the will?
I don't know if she was surprised. I really don't know the answer to that. I can't really get into her mind on that.
And very quickly, I know that there are also reports that documents show that John Henry tried to trademark his father's name before he died, and there was speculation that he was interested in selling his father's DNA. Can you comment on that?
That I can comment on. It is absolutely 100% false. Lawyers don't have to take every case they're involved in. If I thought for 1 second that Claudia or John Henry was in any way interested in profiting from their father's body, I would not be involved in this case.
And I know that all three of the children met yesterday trying to iron things out. That didn't happen. What is the next step?
Well, the next step for us, we're not giving up on that. We feel that was a first step and a good step. And from everything I've been able to read, I understand that they feel the same way. I'm hoping, perhaps hope beyond hope, that the judge will step in and force yet another day of mediation. I think we had a good start, but it was just that, Katie, a good start. And this family needs to make every effort to resolve this matter privately, as most of us do in our own lives, and only use litigation as a last resort, because one way or the other, it will end their family forever if we have to go that route.
All right, Robert Goldman, attorney for John Henry and Claudia Williams. Mr. Goldman, thanks very much.
Thank you.
It's 7:22. This is Today on NBC.